Good afternoon, everybody. I am Joanna Craney. I am a financial advisor and special needs planner with Empowered Financial Strategies. And I am so excited to be here today to welcome Randy Steen, who I've known for quite some time. And she has offered her expertise today to highlight the work that she is doing from a legal perspective in the special needs community. My specific specialization is working with families who are caring for a loved one with special needs. And this type of planning, it's unique. You know, we're planning for 2 lifetimes of income. We have to take into account government benefits, special needs law, and care management. I have firsthand navigated the disability world, first as a sibling to 2 siblings with special needs, and now myself as a caregiver. So I am sitting on the same side of the table with a lot of families navigating this really complex and overwhelming world. And so I welcome Randy Steen. As I mentioned, she has been practicing trust estate, special needs planning, and business and tax law for nearly 3 decades. I will say, Randy, you don't, you look really too young to be doing this for 3 decades. What is your secret? I should maybe start off with that question. But she really has a vast amount of experience in the special needs community. And she also comes from a parent perspective, raising a daughter with pretty rare special needs. And so I really just want to first welcome you, Randy. Thank you for taking the time out of your day, because I know you're a very, very busy woman, and thank you for being here.
Oh, thank you for having me, Joanna.
Yes, so let's just kick this off with one of my first questions is, you see a lot of mistakes in working with families who are caring for a loved one with special needs. What are some of the common mistakes that you see, and how do you help your clients avoid them?
I think, that's such a pertinent question. One of the most common mistakes that I see, which has nothing to do with a special needs trust itself, is that families feel that they don't need to leave their child with special needs or their loved one with special needs any money directly. They think that they can leave it to a loved one, a sibling or something like that, and they will take care of their child with special needs. This is a tremendous mistake. I know you see it too, and they feel like they can trust the child. And lots of times we can trust the sibling, and it has nothing to do with trust. Bad things can happen. If we leave money to a sibling, it becomes subject to their creditors. It becomes subject to a divorce if they have one. If they happen to get ill, if they die prematurely, it will go according to their will. And basically, it is just not protected. This is a really huge common mistake. And the other huge mistake that I'm seeing lately, and I don't even know if you and I have had the opportunity to discuss this, but when people have a child that is on consolidated waiver, they get the granddaddy of waiver, the thing that we all want for our kids. They all of a sudden think, I don't have to leave them a lot of money in the special needs trust because now everything is paid for and all of their needs are paid for. Well, this is a tremendous mistake. And I have to talk parents off the ledge, because waiver does pay for a tremendous amount of things, but it doesn't pay for everything. And we forget that. We forget that quality of life issues cost more money. And we also forget all the things that we are doing, and that sometimes our caregivers, the good ones, are not really making a living wage. And special needs trusts can help supplement and pay a living wage to caregivers to help keep good caregivers in our children's lives, to help take them to that ball game or to do those enrichment things that waiver will never pay for. Okay, so those are common mistakes, as well as things like not having proper provisions in trusts.
Yeah, no, that's fantastic. And it's so interesting that you say that, because I was just having this conversation yesterday with some individuals that are actually personally supporting our family. And they say there's a high turnover because, as you mentioned, they're not making a living wage. And so if you're in the special needs community, you know this all too well, unfortunately, that there's a high turnover with supports coordinators, with agencies that are supporting the special needs community, because if they're accepting waivers, Unfortunately, the funding is not, for a lack of a better term, it's not enough. It's not enough to support their own families. And so, yeah, it is really, it would do the family a disservice if they were just depending on consolidated waiver to take care of everything. So just leading into my next question, because we talk about this in every conversation that we are with our families, is what estate planning documents are really important to have in place for parents and caregivers and their families.
So to me, we start with the basics of what everybody needs. We all need powers of attorney for healthcare. We all need powers of attorney for finance. We need wills if we care about how our property is directed, and we need special needs trust for our loved ones with disabilities to make sure they continue to get their benefits. Critical, critical, critical. Everybody who's listening needs these documents. We all need powers of attorney. Our neurotypical kids need them. We need them. We all need these things.
Yeah. You know, Randy and I have done webinars for the past several years. And one of the things she always says, and it really has stuck with me, it's like, if you don't have a will in the state of Pennsylvania, the Commonwealth of Pennsylvania will make one for you. And I can assure you it's not going to be the one that you want. So having these documents in place is really critical. You know, speaking of powers of attorney, I know a lot of our clients come to us and they're on, they question, well, what's the difference between a power of attorney and guardianship, and really, how do I make that decision? Can you shed some light on that?
It's very difficult for parents. And I think the crux of why it is so difficult for us as parents, as our instinct is, I want to keep my child safe. And I think that is the underlying instinct, is to keep my child safe. And we tend to lean towards, in our minds, guardianship, because that, when we know our kid has needs, that sort of seems like the safe play. And sometimes we'll get advice from doctors and things like that, that a guardianship is warranted. The problem is the courts do not see it the same way. Guardianship versus powers of attorney. Guardianship, plenary guardianship, is what people come to me for. It strips somebody of all of their rights to make any decisions. It says they have no capacity to make any decision making. And that could be true if it's an extreme case. But what it does is say they have no rights to make any decisions over their bodies or over their monies, no rights to sign a job application or anything like that. And parents tend to think that means they're going to be safe if they make bad decisions about who they hang out with, or drugs, or are promiscuous. And it doesn't do any of that. It's not going to keep your child safe from any of those things. But it can do certain things if they are resistant to life-saving medical treatment and things like that. It can do those things. But judges do not like guardianships. So they are not granting them very easily. It is a struggle for us to get them. Guardianship in Pennsylvania is expensive. It is limited, for the most part, to 2 people on the guardianship, which means that it's usually parents. And then when parents pass away, we are back in court to do another guardianship. What it does is give you definitive control. It does do that. What it doesn't do is give us any kind of robust line of descent. So we are back constantly seeking new guardianship. If somebody dies, if 2 people die, are we fit to remain a guardian and get that line of descent? But it's not going to change somebody's bad behavior. And it's really important to let people understand that. It's not going to necessarily keep somebody safe. Powers of attorney are different. Powers of attorney allow us to help and support people, just like we get powers of attorney if we become disabled, if we become ill, if we need help, if we can't speak for ourselves, whether it's medical or financial. Same thing with our kids. Same thing if we have kids who are 18 and going away to college. We need healthcare powers of attorney because otherwise we can't speak for them. Same thing with our kiddos who have special needs. So they allow assistance and support. They do not take away rights from anybody, but they allow help. It hinges, and the big question becomes, does somebody have capacity to sign? That's the issue. Capacity to sign a power of attorney versus having to seek a guardianship. And capacity to me is always, do you understand the nature and spirit of what you're signing? And that doesn't mean understanding all the legal words. It does mean Do you know who you are? And do you understand, can mom and dad help me with my medical decisions? Can they help me with money? And that really is for the lawyer to assist you with, okay? And that is important, that you work with somebody who deals with children with needs and adults with disabilities all the time, and not someone who will hear a diagnosis and assume that a diagnosis means you're not capable, because it doesn't.
Right. And you know what? You said something that I think is really critical in this conversation, is that you work with an experienced professional that is going to support you. I can tell you time and time again, I meet with clients and they're not working with a estate planning attorney who's well versed in special needs planning. And that's where the mistakes are made, or an attorney that will not give the pros and the cons of both guardianship and powers of attorney. And I think that is so critical, because that's where the mistakes are made. And so I highly encourage, if you are caring for a loved one with a disability, that you work with people who are specialized in this area of planning. You don't want to have to go back and fix the mistakes, because they could either be not fixable or they could have cost you a lot of money. So really, really critical point there, Randy. Leading into my next part of the conversation is really around special needs trust. Most often when we're working with families, they're coming to you or they're coming to me to collaborate on the legal and the financial piece of a special needs trust. Can you tell our audience today, well, what is a special needs trust? What are the different types of special needs trusts that are out there? And can anybody put money into a special needs trust?
Sure. A special needs trust is really a vehicle that is designed to help us address the fact that once our children are 18, they cannot have more than $2,000 in their name and qualify for benefits and resources like SSI and Medicaid. And then we get into waivers and food stamps and all other kinds of things that we want for our children, okay? So those things are need-based. They are not entitlement programs. So they are need-based for our kids, SSI and Medicaid and things like that. They cannot have more than $2,000 in their own name. At 18, they're considered emancipated. So how, with $914 a month in SSI, which is supposed to cover room, board, and utilities, are they going to actually live? When we're here, we help supplement them. When we're not here, we have to find a way to leave them money, assets, and resources to help supplement them in a way that is not going to negatively impact their benefits. And that is what a third-party special needs trust does. That's what people come to see me for. The trust says very clearly that the money in the trust is meant to supplement and not replace any government benefits, state benefits, nonprofit benefits, anything, any resources our children are getting from all sources out there, that it's a supplement to those benefits and not a replacement for those benefits. That's the crux of a special needs trust, a third-party special needs trust. The entire purpose of the trust is to provide quality of life. That is the entire purpose of the trust, that above and beyond all the benefits that are supposed to take care of the basic needs, that the trust is going to, the best written trust, keep our children in their accustomed standard of living. That's the idea. What I tell my clients is to picture it as, when you're here, you are the parents, you are taking care of them. When you are not here, the trust is to become the financial parent. Third-party trusts are what most people come to see me for. That is what I consider proactive planning. Third-party simply means anybody other than the person with a disability can contribute money to that trust. So think parents, grandparents, siblings, aunts, uncles, anybody except the disabled person. Third party also means, in my mind, all in the family. The money stays in the family. So when our beneficiary with special needs passes away, that can go to other children, it can go to other family members, it can go to charity. It stays however we want it to stay. It is a private trust. A first party special needs trust is more reactive planning. When a third party trust is proactive planning, a first party trust is more reactive planning. So what this means is it is first party, the disabled person's own money creates it, okay? And usually after they're the age of 18 and they have benefits, and this money would disqualify them for benefits. So it could be because a well-meaning parent, grandparent, sibling, aunt, uncle leaves them an inheritance. Could be because they are the beneficiary of monies from an accident, car accident or something like that. It could also be because there's a divorce that went on and they are receiving child support after 18, because child support can continue forever in Pennsylvania if you're disabled, but we can't have it come into a child directly after 18 because it would knock them out of benefits. So it might have to go into a first party trust. But a first party trust, there's a catch. If it is the child's own money, the state of Pennsylvania, the Commonwealth, gets to get paid back when the child dies. Every cent that they have put out in benefits and resources. It's a payback trust. So the chances of it going to other beneficiaries like family members are very slim, okay? So for these first party trusts, my goal is always that there is no money left to be paid back. That is the first place we spend money, is those trusts, because we know it's probably not going back to family members. And if there's no money left in a first party trust, they can't go after anybody. It's just there's no money left in it. We've used it. It's depleted. But the good thing for parents to know and loved ones to know is if we do get that gift, if we do get an inheritance that goes to our child in their name alone, if we do get a windfall, if something happens, we are always going to take money for our children. And there's a solution for that. We can create a first party trust. We never say no to money for our kids. That's the difference between third party and first party. And anybody can contribute to the third party trust that we create for our children. So we've created one for Sarah. If we have a grandparent that wants to contribute and make a gift, we're good. We're open for business. If we have a friend that we want to, Joanna, we've even had somebody inherit $1 million from somebody in church into their child's third party trust as a gift that nobody was expecting. So we are open for business once we create those trusts, and we will take those gifts.
That's excellent. Thank you for clarifying the differences, because I think that is often an area where families are they're confused about the different types of special needs trusts that are out there. They're Googling and they're getting, mixed information. So thank you for clarifying that. Oftentimes I hear parents say, I don't have a big estate, or, how much is this going to cost me to meet with an attorney? And these are obstacles that get in the way from taking that first step to reach out to an attorney like yourself. So, if you could just lend some advice to these parents to help them take a proactive step in these very critical areas of planning.
So what I always say to people is, I hate the term estate planning because the word estate scares people. But the truth is, if you own a house, you have an estate. If you own a car, if you have a bank account, you have an estate. You don't have to be a millionaire or a multimillionaire to have an estate. The state of Pennsylvania will happily tax you. That is your estate. Your house, your car, your things, it doesn't matter the value. That is considered your estate. So you have something, that's your estate. So don't get hung up on how much it is or anything like that. As far as taking the first step to see a lawyer, my first meeting's complimentary. Most lawyers are not. I'm going to tell you that up front.
I know that for sure.
My first meeting's complimentary, and there is a reason for that. I know you don't love to talk about death and taxes. Okay, I know that it's not fun for people, but I want to get you in the door because this stuff is important. Okay, some lawyers charge on an hourly basis to do this kind of work, and you can check that out. Most people are pretty forthcoming about, if they charge on an hourly rate or they do it on a fixed fee basis. My work is done on a fixed fee basis, and people should be pretty forthcoming about that with you. How do they charge for their work? And the way I do it is at the end of my first meeting, I have a pretty good idea of what people need, and I will quote a fee at that time, because everybody's different. I can't quote it in advance because I don't know your circumstances. What I always say to people is, I don't discount my fees for millionaires. I don't. They ask, but I don't. but I do work with people who need me and can't afford me. And that's just the way it is. I can't speak for other lawyers, but that's what we do at my firm to make sure that everybody gets what they need.
That's awesome, Randy. I love working with you. You know that. I think you are so fair and you really make an incredible impact in the special needs community. If people want to reach out to you to set up that complimentary meeting, how should they reach out to you? What's the best way?
I think the easiest way to schedule is always via email. It's my email is rsteen.law, so it's rsteenlaw@gmail.com, or they could always go to the website if they want to poke around, which is www.rsteenlaw.com. If you want to learn a little bit more about the firm and what we do and things like that. But either way works. It's always good to check around for information.
That's great. Well, I just want to say thank you again for taking the time out of your day to really highlight your impact in the special needs community and how you serve families. This area of planning is so very important. So thank you for your time. For our audience, again, we had Randy Steen on today, attorney and special needs and tax attorney. So grateful for her time. I'm Joanna Craney, financial planner, special needs planner with Empowered Financial Strategies. If you have any follow-up questions, please reach out to us. Our website is www.empoweredfinancialstrategies.com, and our contact email is info@empowered-fs.com. Thank you again so much for being here, and that's all for today. Have a nice rest of your week.